All rise.
The Kosovo Specialist Chambers is now in session.
Please be seated.
Madam Prosecutor, or Madam Court Officer, would you please call the case?
Good morning, Your Honor. This is file KCBC 2023-12. The Specialist Prosecutor versus Hashim Thaçi, Bashkim Smakai, Isni Kilay, Fadil Fazliu, and Hayreddin Kuchi.
Good morning to everyone in and around the courtroom and to those joining us remotely. Could we have appearances, please, starting with the prosecution?
Good morning, Your Honor. Josh Hafetz on behalf of the Specialist Prosecutor's Office, and I'm joined this morning by my colleagues Julie Mann, Claire O'Connell, Brent Hicks, and Dirk Jan-Lamont.
Thank you. And now appearances for the defense in the order appearing in the indictment, please.
Good morning, Your Honor. My name is Specialist Counsel for Mr. Hashim Thaçi, and my name is Sophie Benego, and I'm here today with Mr. Lirim Gravesy, Miss Leah Alix Cornelissen, and Miss Lisa Clemens. Thank you.
Your
Thank
Honor,
you.
it's Jonathan Rees, King's Counsel. I appear on behalf of Bashkim Smakai. Mr. Hugh Bowden, co-counsel, is also present in the courtroom. Can I say this, Your Honor, that due to delays in an on-running murder trial that I have at the moment, I'm going to have to leave the hearing after an hour. But Mr. Bowden, co-counsel, is fully briefed and will be present throughout the day to represent Mr. Smakai's interest for the remainder of the hearing. Thank you.
Yes, I was informed, and thank you very much for that, Mr. Rees. Mr. Edwards?
Good morning, Your Honour. I represent Isni Kilay, together with, on the far right, Admir Berisha. Immediately to my right, Eva Kalb, my co-counsel Joe Holmes, and appearing remotely, Omar Solomon. Thank you.
Your Honour, good morning. I appear for Mr. Fadil Fazliu this morning. I'm assisted today by Yu Qing Liu, who sits to my left. Thank you.
Good morning, Your Honor. My name is Alexander Admiraal, and I'm Specialist Counsel for Mr. Kuchi.
Thank you very much. Could we now have an appearance from the registry, please?
Good morning, Your Honor. Jonas Nilsson, Deputy Registrar for the registry today. Thank you.
Thank you very much to all of you for being here, and to the accused who are present in the courtroom in particular. I am Christopher Gosnell. I am the single judge in this case. I am sitting as a single judge pursuant to Article 15.2 of the Law on Specialist Chambers, which so permits in respect of alleged offenses not classified as serious crimes under Article 22 of the Kosovo Criminal Procedure Code, which is the case here. On 12 November 2025, the pretrial judge transmitted the case file in this case to me. On 17 November 2025, as required by Rule 116.2 of the rules, I issued a scheduling order for today's hearing requesting submissions from the parties on a number of topics relevant to preparing for the opening of trial proceedings in this case. In that order, which is filing 549, I indicated that I would exercise my discretion to combine the trial preparation conference under Rule 117 and the SPO preparation conference under Rule 18 into a single conference to take place today. I note that the SPO in its submissions in filing 559 has requested that the two hearings be bifurcated, which I take to be a request for reconsideration of my decision. I will reserve my decision on that request until after today's hearing, but I would hasten to add that regardless of how this hearing is ultimately classified, I will not hesitate to schedule further status conferences at the SPO's request as may be necessary for the preparation of trial, and the classification of today's hearing will not determine the start date of trial. Before we go any further, I would like to remind everyone intervening today, especially given the number of us who may share a common first language, to speak at a reasonable pace and to avoid overlapping speakers, please. That's the only way that our invaluable interpreters and stenographers can do their work, which is also vital to ensuring that the accused fully understand what is being said. I would ask you all as well, please, to try to formulate your submissions in a way that avoids having to go into private session. But of course, if necessary, we will do so. If anyone becomes aware of something having been said that requires a redaction, please do send an email immediately to the CMU officers as per the usual procedure. In terms of the schedule today, we will sit now until 11 a.m. when we will break for half an hour, and then continue from 11:30 until 1 p.m. Thereafter, and if necessary, we will have an afternoon session from 2:30 until 4 p.m. I want to thank all the parties for the very helpful submissions in preparation for today's hearing, which considerably narrow the topics that we need to discuss today and assist in clarifying the points of disagreement as well as agreement between the parties. And I propose to proceed today by asking at first a number of questions of the parties, and then at the end to permit or invite the parties to raise any additional issues that they consider necessary. Of course, bearing in mind that there's no need to repeat submissions you've already made in writing. So I'd like to start on a topic where there seems to be some convergence of views, and that concerns the bar table motion. And I note that both the prosecution and the Thaçi defense, at least, appear to share the view that this motion should be filed in advance of trial. I read that the prosecution is prepared to file that motion during the week of 15 December 2025. And I note that Mr. Thaçi did not object to the timing of the filing of the motion, but does request that the briefing schedule be adapted to ensure that the defense has adequate time to respond, including by suspending the deadlines for responses and replies during the judicial recess. And that was at paragraph 22 of your filing 568. I've consulted the calendar, and I note that that would imply a period of about 40 days to respond, assuming that the bar table motion is filed on the 15th of December. Can you comment, please, Ms. Ménagement, on the need for such an extensive period in order to be able to respond to the prosecution motion?
I thank you, Your Honor. My concern was just to note, depending on the number of items tendered in writing and depending on the legal issue raised, we may need further time. At this stage, I'm not sure about the number of items raised, so I just wanted to reserve that position. I'm not sure we need absolutely now such an extension, but we may need to, and in which case, upon reception of the bar table motions of the prosecution, we may seek such an extension. Thank you.
Thank you, Ms. Ménagement. I believe Mr. Thaçi is raising his hand.
Indeed, he told me at the beginning of today that he wanted to make a brief observation. I don't know if you want to give him the floor now or at the end of the hearing. It's not related directly to the calendar as such.
May I suggest that we will continue on the agenda, and Mr. Thaçi will certainly have an opportunity before the end of the hearing to make his intervention.
Thank you.
Does the prosecutor have any comment on the nature of the bar table motion, whether or not, or the time and the timing for any responses?
Thank you, Your Honor. We defer to the court on the timing of the response. What I can say is, while there will be a significant number of items as items in the bar table motion, which we've already forecast, or any other motion for admission of evidence on the paper, the categories are quite discrete and they're known. So just saying a number doesn't help, right? There may be 200 records paper records from the detention center that are all really have one basis behind them, one legal justification behind them. So they're really one for the purposes of deciding the motion. So, and I think we've broken down the categories, nearly all of them, in the filing that we've already made. And we've been pretty transparent about that. And I will also note, we've already had an inter partes discussion, which was quite useful, and I thank all sides for that, to attempt to narrow down the categories we have to come to Your Honor on, and may be able to find agreement on one or two of them. And so we'll endeavor to keep doing that. Obviously, it will be Your Honor's discretion whether to admit, even if there is no disagreement, but there may be some on which we agree, and we are able to present that to you.
And Mr. Hafetz, do I understand that you're planning on filing a bar table motion that is similar in form to bar table motions that have been filed by the SPO in other cases?
Yes, Your Honor.
Any other defense teams have any comments on the filing of a bar table motion in advance of trial or the timing for any responses?
Your Honor, the prosecution ought to, if they intend to make an application of that type, they ought to make it as soon as possible. The time that we will need to respond to it and how thereafter it's dealt with is a matter that in our submission is better addressed once the prosecution have made such an application. Then we can see it, then we can consider what's in it, we can consider to what degree it's likely to be controversial and to what degree Your Honour is going to be exercised with having to determine it in whole or in part. It seems to us that the best way forward would be for Your Honour to set down a very strict timetable for the prosecution to make any such application, not only setting out what they seek to adduce, but the basis upon which they seek to adduce it, setting out what they say are the grounds for admissibility, and then we can consider it, and if necessary, either in writing or via a further status conference, we can make submissions upon the appropriate way to deal with that in terms of both order and time to respond. Because it may be, Your Honour, that there are parts of it that don't need to be immediately resolved. There may be other parts that do. Suggesting, trying to work out at this stage a all or nothing approach in our respectful submission is probably not the most sensible way to approach this. I think everybody, including, of course, Your Honour, most importantly, Your Honour, would be assisted by the prosecution actually getting on and making such applications as they think are necessary to prepare their case for trial. Once we have them, we can then all, in an educated way, consider the best way to deal with them.
Thank you, Mr. Rees. Any other defense submissions on this point?
No, thank you.
Your Honor, I just wanted to clarify. I think you have mentioned 40 days to respond if we stay, but I see if they file on the 15th of December, we would have to respond by the 25th of December. So I was just considering an extension, for instance, until the first working week of January, like by the 5th of January, which would be far less than 40 days. Thank you. Just want to also point out that I agree with my colleague, Mr. Rees, that we may just seek an extension upon reception. It may be the simpler way to deal with it. Thank you.
Thank you. Any other submissions, Mr. Young?
No, thank you.
No, thank you.
Thank you. I think we will, in due course, issue a scheduling order that deals with this issue first, probably a separate order on the timing of the bar table motion. So that will either be decided later today or no later than Monday, just for your information. I'd now like to turn to the question of witnesses, testimonial evidence to be heard in this case. And I thank all parties for very constructive and in some cases very specific estimates concerning how much time they'll need with witnesses. The prosecution, I note, has submitted that its case in chief is estimated to last no longer than 2 weeks and proposes that all the witnesses be heard in a single block starting in February. And since the duration of the testimonial case could have an impact on when trial is scheduled to start, I want to make sure that I have the clearest possible understanding of the anticipated duration of each witness. Now, in respect of witness 7, I note that the SPO has confirmed that it will tender, pursuant to Rule 154 of the rules, the 3 previously disclosed statements as his testimony in chief. Can I just clarify whether the prosecution considers that there is any possibility that the testimony in chief, not the issue of cross-examination, but the testimony in chief, could be affected by the outcome of any ongoing investigations?
It could, Your Honor. It really is difficult to say until we have the results of those investigations. It is possible that it would not be affected. We're not talking about hours more testimony, but there are details of which or additional facts that may be elicited through him or evidence that may have to come in through him depending on the results of the investigation. I just can't answer that right now.
Is the expected scope of any additions to his testimony limited enough to say that it would be dealt with orally, or would it be your intention to prepare an additional statement and tender that testimony in that manner?
Again, it's possible that it might require paper, Your Honor. So it's just impossible to forecast that.
Because at first sight, it appears from the statements that have already been produced that the direct testimony is already fairly comprehensive, even in respect of the ongoing investigations. So without getting into any additional details that might require us to go into closed session, I was curious to know what exactly might be the subject matter of that additional testimony from witness 7?
So what I can say, Your Honor, in open session, I think, and I'm happy to go into private session to address the point, but this may suffice. What I can say is the type of additional information that would have to come through paper through that witness, in other words, in the form of additional piece of a declaration, would be very limited in scope. And it would be of the nature of the things he's already described.
And I note from your pretrial brief that the estimate for his oral examination was 2 hours. And subsequent to that filing, it was subsequent to that filing that the submission was made that his direct testimony would be tendered in written form. So does that mean that your estimate for the live testimony of the witness is reduced or not?
Not necessarily, Your Honor. It depends one, on the outcome of the 154 motion, if that is accepted, of course, but also there will be additional materials that he needs to speak on that are outside the scope of the full declaration. And so some of the evidence that we intend to adduce would have to likely be put through that witness and be questioned on. So that may take up part of that time. The other thing I just want to go back to, because these are directly connected, and Your Honor has raised them. As we said in our filing, part of the length of the anticipation of the prosecution's case is dependent upon the resolution of the bar table motions that we're talking about. That's obvious and to me pretty normal in this situation. And so in their submissions, at least the Thaçi team appeared to agree with us that, again, the decision on those motions will be of critical necessity to the length of forecasting the length of the trial and to actually doing it in an orderly fashion. And that's part of why we've emphasized how important it is to put those before you and have them decided.
Are the defense teams in a position now to comment on whether they intend to cross-examine witness 7? In this respect, I thank Mr. Rees for being very clear on that point in his written submissions in his pretrial brief. So I'd like to ask the other defense teams whether they have any position are able to give a position on this point at this time.
Yes, Your Honor. On our side, we intend to cross-examine him. Thank you.
Your Honor, yes, we also intend to cross-examine him. It will be a focused cross-examination that won't take very long, although I'm always reluctant to say precisely how long, but certainly within one trial session. If I may, while I'm on my feet, make this observation, because my learned friend has just, for the SPO, has just indicated that notwithstanding the 3 very full statements of witness 7, there may be additional oral testimony relating to additional material outside the scope of those 3 statements. And it occurs to me that if that is the case, the SPO has the time to reduce that additional information into writing, into a 4th statement, which could shorten any additional oral evidence to very little, if nothing, and that assists both Your Honour and the defence in terms of notice of what this additional evidence, what this additional material would address. I simply raise that because it may be something that the SPO could consider. It may be something that Your Honour would consider making an order about.
Thank you, Mr. Edwards. And just to say, of course, that this is an issue in which consultations also between the parties could be helpful if they can come to an agreement on that particular question. Mr. Young?
Your Honor, thank you. The position is that we would certainly like to question witness 7, but don't anticipate it lasting more than an hour or 2 in relation to various matters. In relation to the issue of calling live evidence, obviously this trial is document heavy and short on witnesses. We see the prosecution appear to be suggesting they want to rely upon 3 witnesses. All I do ask Your Honour today and the parties to consider is some sort of order. Helpfully, in the inter-parties conference that we had, we were given an idea of the order of possible witnesses. I'd be grateful if we could be told well in advance of the trial the order of the witnesses. And if I may defer my other point and come back later in the day on that, because I'd like to address Your Honour in relation to the policy on calling witnesses that the prosecution have adopted. Thank you.
Thank you. Mr. Admiral?
Thank you, Your Honor. It depends on the outcome of the ongoing investigations.
Thank you.
Your Honour? Your Honour?
Yes, Mr. Rees?
Obviously, I have indicated our position in relation to witness 7, but I nevertheless do wish to raise something that concerns me. and it arises directly out of something that Mr. Havertz has said on behalf of the SPO, and indeed our earlier discussion. Mr. Havertz concedes that we would all be better informed dealing with trial preparation matters if, for example, the SPO had provided in advance of today's date their applications to admit documentary material other than via a witness. The bar, as they call it, a bar table motion, setting out what they say is the basis for admissibility of such material. I agree with him. I also observe that these matters have been extant now for, I think, well over 12 months. And the prosecution ought to have prepared for trial by now. That's why I repeat, firstly, that there ought to be a very short timetable imposed upon the prosecution to serve detailed applications to adduce any evidence via the usual route via a oral witness, and that should be done immediately, frankly. Secondly, the discussion that was just had in relation to witness 7 seems to have been predicated, at least on the SPO's behalf, on the basis that the whole thing is a moving feast, and that whether or not they have further testimony to adduce from witness 7 depends on their ongoing investigations. Well, that's not quite right, because in due course, any attempt to adduce further evidence will have to come with an explanation as to why at this late stage they are still seeking to add to the scope of their case. I just wanted to make that clear, because it does seem to us that the SPO seems to be working on the basis that their time is unlimited.
Thank you, Mr. Rees. I'd now like to move on to witness 9. Can I inquire of the prosecution whether you have disclosed any statements in respect of this witness to the defense?
Your Honor, we've disclosed what I believe are 4 official notes from that witness. They're not statements as such in that they were formally taken with in a formal setting, but they are official notes where he has written down how he went about extracting evidence, in essence, extracting evidence from electronic devices. That's what those are, and he's prepared to give testimony on that. And he is the other Rule 154 witness.
So just to be clear, does that mean that you intend to tender the 4 official notes as the 154 statement, or will there be some sort of an amalgamation of the statements?
We would intend to submit those as his 154 statement, subject to, Your Honor, the addition of any additional similar note he needs to make, which would be in the number of, again, 1 to 3 or 4 pages, for any of the additional material, for example, that he extracts from Mr. Kilai's phone, which was only obtained 2 months ago and is about to be finished with its examination. So he would do a similar note explaining that, the content of which would be just to essentially repeat, unless there's anything technically different about it, how he went about making those exhibits.
Thank you. And now I'd like to turn to the defense, and I realize that it may not be possible, of course, at this stage, and that all estimates are just estimates, but could I please receive from you at this point your present intention in terms of cross-examination of this witness and how long you can estimate it might take?
Thank you. We are likely to cross-examine him, but I have I can't tell you, I can't provide you now a time estimate. Sorry.
Mr. Rees? Mr. Rees, I don't know whether you can hear me.
Apologies, my lord. I was just looking for the mute button. Our position is the same as that expressed by Ms. Menegan.
Thank you. Mr. Edwards?
Yes, ours is the same position as well.
Oh, I'm sorry, but the same position as well. Thank you.
Same position as before, depends on the outcome of the ongoing investigations. Thank you.
Great, thank you. Now we come to witness 8. and I understand that there already have been certain disclosures in respect of this witness. But can I confirm that one or the other of the disclosures that have been made, including the statement, do they constitute the expert report? And when does the prosecution intend to formally tender that as an expert report?
Thank you, Your Honor. The expert report is not the statement we took from him. That was to clarify his report. We have disclosed the expert report, which is dated 14 December of 2024, and we will tender that through the paper if Your Honor needs, but we intend to rely on that as an expert report. So for purposes of Rule 149, from our perspective, that clock has been triggered. I understand, and I'll note that Mr. Thaçi's defense has requested additional documentation, which we will provide pursuant to Rule 1023 on Monday, pursuant to the underlying questions that led to the report, which are, from my perspective, already in the report, but I understand the question and I'm happy to provide it. And we will provide that, I believe, on Monday. But for our purposes, either the already disclosed report and our putting him on the witness list with the intention to testify as an expert has triggered the 149 requirement on the other side, or certainly the provision of the 1023 question that led to it would do it.
All right, thank you for that clarification. I think that is ERN 118299 to 118304. Perhaps you could just double check and confirm that, but it was a matter of just confirming that is indeed the expert report that is being tendered pursuant to 149.1.
Thank you, Your Honor, and I'll check that while we're here.
Thank you. Do any of the defense team, same question in respect of this witness, are they able to provide any estimates as to the cross-examination of this witness? I note in particular the position that's been set out in the Thaçi pre-trial brief in respect of the matter of printing. So that's what provokes the question, whether or not there's a present intention to cross-examine this witness, and if so, for how long, if such an estimate can be provided, please.
Yes, Your Honor, we intend to cross-examine him, but I'm not able to provide the time estimate yet.
Mr. Rees?
We similarly reserve our position.
Is it the same position for all the defense teams? If not, perhaps you could just intervene and say otherwise.
Well, Your Honor, yes, that is our position. My learned friend for the SPO didn't mention it a moment ago. We too have made a request for additional documentation arising out of the expert report. I think it's 9 or 10 further documents that I didn't copy, Your Honor, but depending on the outcome of that request for additional evidence, that may inform our cross-examination estimate. But for now, we will cross-examine him. We just don't know at this stage for how long.
Your Honour, may I say on behalf of Mr. Thaçi, it's very unlikely that we'll have any questions of witness 8, but if I may we reserve our position. Thank you.
Mr. Admiral?
Same as before.
When you say same as before, you mean the same position as in respect of witness 7, or the same position as Mr. Young just expressed?
No, as witness 7. Thank you.
Thank you.
Your Honor, if I may, just one moment on this topic.
Yes, please.
And I thank Mr. Edwards for raising that. We did yesterday receive the 1023 request he's referring to, and we will review that and deal with it in due course. So I thank you for that. I think this may be, I don't want to sidetrack, Your Honor, but I do think, since we're talking about Rule 149 and the expert, as I understand it, the defense from some of the filings, one or more of the defense teams may call their own expert, and it may relate to this same topic, right? The printing and computer materials. If that is the case, pursuant to 149, we would just ask Your Honor to set a reasonable date at which, upon receipt of the defense, when they get their own expert report, if they do, or reports, that those are disclosed timely. This is not something that can be just disclosed like 2 days before the expert comes. We would need to interrogate that.
But are you suggesting that that those reports should be forthcoming before the appearance of your witness?
I'm not necessarily suggesting that at all. I'm just suggesting that if there is no date right now floating out, and we don't know how many reports that they're going to be.
Thank you. And then that's not the end of the potential prosecution witnesses, because there is a motion, or at least a request in the SMAC-I pretrial brief that the prosecution be obliged to call a particular witness. So without, at this point, going into the merits or litigating the matter here, I first of all just wanted to canvass, please, the prosecution's position on that request.
Your Honor, our position is based on the case. We are in no way obligated to call that witness, and we don't intend to at this time.
And Mr. Rees, again, without litigating the matter here in this status conference, what's your position in respect of what the prosecutor has just said?
Well, that's the first time that Mr. Havertz, on behalf of the prosecution, has indicated that firm position. I'm grateful for that matter to be clarified by them. We will reflect on it and bring whatever motions and applications we thereafter think are appropriate.
Thank you, Mr. Rees. So now I'd like to turn to really the very significant variable in respect of the start of trial in this case, which is the matter of ongoing SPO investigations. And I have a number of questions that I would like to direct to the prosecution in the first instance. And after we've gone through those questions, I will ask the defense to comment globally on the responses that have been forthcoming from the prosecution. Now, I note that in prosecution filing 559, the SPO's position is that trial cannot start until, and here I quote from paragraph 3, the limited remaining investigative steps have been completed. And also at paragraph 3, you estimate that that trial could commence at the beginning of February 2026. But I also note that your estimates as to when investigations may be complete, and here I quote from paragraph 7 of your filing, depends on when the SPO receives the material from a particular external service provider, and that there may even then be, and I quote, additional investigative follow-up, unquote. You then refer to an investigative step at paragraph 20 that will, and I quote, begin in January 2026, unquote. And we know from other documents provided by the registry that the external provider has informed us that the delivery date can only be confirmed once the work begins in January 2026. So I want to make sure I understand the nature of your submission that trial could commence at the beginning of February. Are you saying, Mr. Havertz, that you're ready to go to trial at the beginning of February, come what may? Or are you saying that it depends on the state of investigations as they may be at the beginning of February?
Thank you, Your Honor. And let me just first answer the question you asked before. That is that Your Honor correctly cited the ERN, and the date of that report is 14 December 2023. So that's my mistake, but that you had the ERN exactly correct. Your Honor, the answer is, to your question is the latter formulation. It depends a bit on the final outcome and resolution of these pending steps, two of which were just, I believe, ordered in the last and resolved in the last 2 days. I'm happy to speak to why those are so essential, but what is clear is nearly, other than one request for a further clarification that's pending regarding a small amount of metadata, which I don't think is going to take very long, and that was already ordered. It's just we've opined that there needs to be a bit more information provided by an external party. Other than that, all of the investigative actions that we foresee, and I'll caveat that just with one caveat, are already underway and due to be finished from what we can tell from what the outside parties are doing by, it seems, no later than mid-January. Now, many or some of the materials come in not English and need to be translated and then need to be analyzed. And they need to be assessed for relevance and disclosed as soon as possible to all the parties so they can then review them. And then we can formulate any request to add any of that material to our exhibit list, which is obviously contemplated by us continuing to go do it. This is not some open-ended and endless investigation. It's quite targeted to the specific things that we've asked for, requested, and have been primarily granted, all within the confines of this case, not some other investigation. I'll also note that the SPO has severely, at this point, narrowed the investigation to focus only on the most relevant evidence that appears to be in the records we're looking for. I'll also note, because I do think it's relevant to Your Honor's question, I thank you for letting me have the floor, the delay that we're talking about in getting this is necessarily triggered by the fact that the two systems we're looking into are both, by definition, containing potentially privileged information and require an outside counsel to review it. This would have gone much faster if we were able to review them ourselves, but that's not what was ordered, not what was contemplated, and in this case, it's appropriate that it's happening this way. But that is the course of the delay. So to answer your question, we do expect these steps to be finished by middle of January. It is possible, and we've said this, that one of the steps in particular may require a very brief targeted follow-up, and it really depends on the outcome of that, and I'm happy to speak about that in private session. It's directly relevant to the case. But in terms of the trial start date, I just want to, because I think that's where Your Honor is headed, since our submissions, and in light of the defense submissions, in light of the orders that have been forthcoming since then, it's pretty clear to me that we'll have that material by mid-January, be able to have requested any follow-up by then or before, because we're expecting some material next week. As we forecast, we may be able to narrow some of the existing requests and reduce some of the work of the outside party. And I think in terms of an actual trial date, what makes most sense based on the submissions of all the parties to be able to complete these steps, understand what the evidence is in the case, and understand and get a ruling on Your Honor's views on the admission of the non-testimonial evidence, that the date that we would suggest would be in mid or late February, understanding that the Thaçi defense wants to start March 2nd. We understand that. But there are quite a bit of moving parts here, not all the investigation, and that to us makes the most sense, but would, to Your Honor's question, allow us to complete these necessary steps and have all of the evidence in front of the court.
The concern that I have, Mr. Hafetz, is that these investigations, as you just alluded to, are not within the control, to a certain extent, of the KSC itself. And as you're well aware, perhaps more aware than anyone, there have been delays and underestimates as to how long certain steps could be, how quickly they could be completed. And I mean, even in your filing 420, at that time, you submitted that the 14th of November 2025 was an appropriate time for transmission of the case to the trial stage. And as you know from the rules, that would, broadly speaking, imply commencing trial within 60 days, which would have implied a trial start date of mid-January. So that was your submission just on 25th of August 2025. And evidently, even since that time, there's been sufficient slippage that now you've pushed back your readiness for trial date by 3 weeks. So what gives you confidence that there will be any less slippage in respect of the ongoing investigative steps right now?
Thank you, Your Honor. And for this, I actually would request that we move into private session so I can speak with just a little bit more detail
Yes.
about the steps.
Let's do that, please,
you.
court
Thank
officer.
you.
Could we move into private session?
Your Honors, we're in public session now.
Now, it's clear from the pre-trial defense briefs that translation is going to be, and potentially transcription is going to be, an issue of relevance in this case. I note there's a registry instruction on requesting translation, interpretation, and verification services. That's dated the 30th of May, 2019. It's KSC BD 14. I draw that facility to your attention because it's evident that the parties may well need to avail themselves of those services, and I would strongly encourage that that be done at the earliest possible moment in time. And of course, that any such requests be, to the extent possible, limited so that they can be accomplished in a timely manner. And if there are any issues in respect of translation, corrections, or verification, they should be brought to the Chamber's attention as quickly as possible. I note that the SMAC-I defense has indicated that neither lead nor co-counsel are available between the 27th of March and June 2026. I just want to indicate at this point that we will be having discussions at an early stage about the scheduling of the defense case. Of course, the opening of the prosecution case comes first, but whenever that happens, soon thereafter, there will also be discussions, and this is, of course, without prejudice to any determinations concerning dismissal of charges under Rule 130, but there will be early discussions about when the defense case could be heard. And so perhaps what I'm about to say is unnecessary and will be moot. But I have to say, Mr. Bowden, that it could be that the Chamber is not going to be in a position to adjourn for a period of more than 2 months.
Your Honour, yes, clearly matters at the moment are somewhat theoretical, as we don't know the dates. Those are existing professional commitments, but existing professional commitments can be altered, of course. At the moment, they are fixed professional commitments, but clearly both Mr. Rees and myself will have to review that, bearing in mind the timetable that Your Honour feels is appropriate.
Thank you for that, and I do understand the position that you may be in, but just to say that that's yet a further reason to have the earliest possible discussions that we can, not premature, but as early as possible in terms of the scheduling of the defense case, and we will do that. We have about 7 minutes before the break. And before we do, I have completed the matters on which I want to ask the parties, and I have not asked the defense any questions, and I've taken note of their submissions concerning the timing of certain matters in which they are required to make submissions, and that's the reason why, not because I'm not interested, but because for the most part it's premature at this stage. But nonetheless, are there any issues that any of the parties would now wish to raise?
Thank you. You know, I understand you are talking about calendar. So I just wanted to inform you that in case 6, the panel further added 2 dates for closing argument on the 16th and 18th of February. So our team won't be available this week. Thank you.
Your Honour, we've said in our submissions that both co-counsel and myself are unavailable for the week of the 16th to the 20th of February of next year. We have commitments of our own during that week.
Your Honour, nothing to add, save that broadly the Thaçi team will be supporting the submissions in terms of timeline of Mr. Thaçi. Thank you.
Nothing to add, thank you.
Does the prosecution have anything further it wishes to raise?
Just one matter, Your Honor. You opened the conference with the observation on the scheduling of the prosecution preparation conference, and I'm just wondering how that interacts with Rule 118.3 in terms of the not affecting the start of the case. It's likely my own ignorance.
Well, Mr. Havitz, I don't propose to issue a ruling right at this moment, but it's my understanding that there is a discretion conferred on the single trial judge to vary deadlines, and so accordingly, if we do treat the current hearing as a Rule 118 hearing, in accordance with the discretion and the authority to extend deadlines, it would not mean that trial would necessarily have to start within 30 days. I assume that that's what you're getting at.
It is, Judge.
Yes. Again, there is an authority to vary deadlines, and accordingly, if your request for reconsideration is not granted, you can be assured that if the single judge comes to the view that the trial shouldn't start until after 30 days, that authority will be exercised.
Understood, Judge. Thank you.
I understand that Mr. Thaçi wanted to make an intervention. Ms. Menegal?
Yes, he had a short observation to make. Thank you.
Thank you, Your Honor. Good morning to everyone. I welcome this hearing being held today, and for that reason I am participating in it because I'm determined and committed to respect the rule of law. However, Your Honor, it is of interest that in this court it is that things that are not permitted to happen in your respective countries are not permitted to happen in this court either. Like any people, we Albanians have our history, our traditions, and our national values and state values. I think that this scheduling of this hearing precisely on this day, on the 28th of November, should have been avoided. Having this hearing today on the 28th of November is a unpleasant surprise to me and to any Albanian. Your Honor, like any other Albanian, every Albanian today celebrates a national, state, and family feast, occasion. It is a day of celebration of dignity and national pride, in which is also celebrated by any free people in the world. Every Albanian citizen, every state institutions today are celebrating in Albania and Kosovo. Therefore, I would like to wish all the Albanians to celebrate the 28th of November united, proud, and with dignity. I hope we'll soon be all together. Thank you.
Thank you for that, Mr. Thaçi. I would just observe that the Chamber scheduled this hearing day after consulting all the parties, and there were no objections to this day for the status conference or for the trial preparation conference. The Chamber will recess for 30 minutes, and then we will return and possibly issue 1 or 2 oral orders. We stand adjourned.
All rise. rise. Please be seated.
I omitted a procedural step at the beginning of the hearing, which was to ask the courtroom officer to confirm who is present at the video conference location along with him and Mr. Cucci. Is anyone else present?
Thank you, Your Honor. This is to confirm that at the remote location are present Mr. Cucci and myself, court officer. Thank you, Your Honor.
Thank you very much. The court will not issue at this time a detailed scheduling order for the start of trial, but one will follow in writing in due course. However, I will issue a first oral order in light of the parties' written and oral submissions in respect of one scheduling matter. And this is the first oral order. The prosecution is ordered to file its bar table motion, that is, to tender all non-testimonial evidence to be presented as part of its case other than through a witness, by 17 December 2025. That is the end of the order. I will now issue a second oral order. The deadline for responses to SPO filing 578, given its very limited scope, is varied to Monday, 1 December 2025. Replies will not be entertained. I'd like to thank you all for your participation in this status conference. Court is adjourned.
All rise.